Thank you all for sticking around. My talk, Patent Inconsistency, picks up on a lot of the themes that we've heard about today, right? The specter of parallel litigation, the possibility of inconsistent judgments between the court and the PTAB, and some causes and maybe some reforms that we might entertain. Now, this work is ongoing. It's sort of part of my broader agenda of work on the PTAB, but I'll point out along the way there are sort of discrete sections of the talk where it primarily comes from one or other paper, and if you're interested in digging more deeply into the data and the arguments in full, I invite you to look at that work in the relevant papers along the way. Okay, so I think we all know by now what the reasons for PTAB review are, both because we've all sort of been interested in the subject and a number of speakers have talked about it. The one thing that I'll point to here is that all of the major pathologies of litigation, right, cost, delay, expertise, access, cost, delay, accuracy, and access, all come down to a question of expertise. And expertise is the main benefit that the PTAB offers. By statute, we have to have APJs who are both technically trained, but also competent in the law and policy of the patent system, which might be very different from generalist judges, who aren't named Alan Albright, and as well as juries, to the extent that they, as H.L. Mencken said, it's a jury trial is putting your fate in the hands of 12 people who aren't even bright enough to get on a jury duty. You're going to have to deal with some things. So the perception that ex parte and inter partes re-exam, which were the first and second generation precursors, it's not that they were inadequate inherently. It's just that they weren't used to the full extent that they could have been, and that the structural features of re-exam didn't really create the incentives that parties and litigants wanted. That's what motivated in 2011 the enactment of the American Invents Act. And in some ways, the PTAB was a little bit caught off guard by how popular it was. The first few years of inter partes review filings exceeded by an order of magnitude the estimates that the agency had published before, saying, you think this is going to be useful, here's how many people we think are going to file. You got to add a 0 to that number before you get anywhere close to the actual filings. What this has led to is greater prominence for the USPTO in the IP system, certainly the patent system. It used to be the case that the Patent Office would do its work under a relative veil of secrecy. I mean, it was all public information, but it was a kind of insulated world that you didn't really get into unless you had both a law degree and a technical background. And it was primarily the Federal Circuit, the CCPA, and then later on the Federal Circuit, that set policy, made substantive judgments about patent law, interpreted the patent statute, and then occasionally something would go all the way to the Supreme Court. But now that we have an expert agency really flexing its adjudicatory muscle, we have the prospect of all kinds of administrative design and redesign questions that really envision a more sophisticated and complex place for the USPTO. Okay, so before we talk about duplication and the problem of inconsistency, we have to begin with substitution, because that's really what the American Invents Act was intended to accomplish. Rather than going to the courts, let's have the agency be the expert preferable substitute. And this is work that I've interrogated empirically in this paper from about 6 years ago, and it's co-authored work as much of it is. The idea of the PTAB as a substitute for the federal courts, the way you ensure that it's a substitute and not just one more place to fight, before you ever get to things like estoppel, if there's a prior civil action on this patent involving the same party or a real party of interest, right, however we define that, that forecloses review in the PTAB. The whole idea is you get one bite at the apple. If you've already had your bite, then go home. Alongside the PTAB, you might have co-pending litigation, but at some point you have to choose. And the at some point is the 1-year time bar, particularly for inter partes review. If you want to seek PTAB review, you have to do it within 1 year of being served with a complaint, or else just stay in the court. It's perfectly fine to do that if that's what you want. Now, errors of PTAB enforcement on the one-year time bar itself, we've gone back and forth on whether that's judicially reviewable. The Federal Circuit, in a case called Cates Reference Publishing versus Apple, said no judicial review. Then along comes Wi-Fi versus Broadcom in 2018, and they had to follow the panel precedent, but then the court went on bonk and said, no, there is judicial review. The presumption in favor of judicial review is not overcome. And then a couple years after that, the Supreme Court in Thrive versus Click-to-Call said, no, in fact, there is no judicial review. So sort of going back and forth, but that seems to be the final word on the question. And then after the PTAB proceeding, of course, estoppel, what the central theme of this symposium has been. A PTAB decision, a final written decision, stops future PTAB proceedings. It also reaches outside the agency doors to stop ITC proceedings, civil actions in federal court, and so on. Now, estoppel covers arguments that were actually made and arguments that could have been made but were not. One of the things I teach in addition to patent law is civil procedure. Does that sound like issue preclusion to you or claim preclusion? Right? It's claim preclusion. One of the things you have to have for issue preclusion is that the issue was actually litigated and essential to the judgment. Claim preclusion lets you take off the table things that were never litigated but could have been. On the other hand, claim preclusion is limited to the parties in front of you. And of course, this extends to real parties in interest and all sorts of other people who may or may not meet the requirements for claim preclusion, Taylor versus Sturgill notwithstanding. And on the other hand, it doesn't just take off the table arguments, legal grounds that you raised. If you're talking about an infringement proceeding where the incentives are very different as compared to a narrowly defined PTAB proceeding on a few points of validity, the claim is not identical either, which is something that claim preclusion requires. So you've got the breadth of claim preclusion, the depth of issue preclusion, which can cut across different types of proceedings, different causes of action, and has the availability of non-mutuality. You're sort of putting them all together into this incredibly powerful thing that the common law wouldn't really tolerate. Now, it's okay because that's how the statute is written, but analytically, it's a little bit weird. And that's a starting point that's useful to be aware of. Okay, what does this look like in practice? We know that's how it was designed. All I've told you so far is what the statute already tells you. Well, there's a considerable amount of overlap, which by itself suggests that substitution might be at work. Most of the patents that are challenged in the PTAB are also litigated in the district courts, about 87%. Most of the parties who seek review in the PTAB as petitioners have previously been sued on the same patent in district court before they file their inter partes review challenge. So this suggests that there's a lot of defensive use of the PTAB based on what's going on in the courts, okay? Seems like exactly what Congress had in mind. And to the extent that people are suing in PTAB preemptively, right, I haven't been sued, but I'm going to go after this patent before it can be used against me. Maybe it's because I just found the patent and think it's invalid. Maybe it's because I saw the patent owner suing a third party and I don't want to wait till they come after me, and so I'm going to take the initiative here. Either way you slice it, you're either using the PTAB as a stand-in for district court defensively, or you're using this PTAB as a stand-in for a declaratory judgment action. But as long as it's a stand-in, it's actually a substitution, then the system is working the way it should. Now, joinder raises some interesting procedural quirks because you can measure overlap on the basis of petitioners and on the basis of petitions. So imagine, and this is broken out by technology because most patent law ends up being technology specific in practice. If you look at the petitioners across all inter partes review broken out by technology area, of all the petitioners who were previously defendants in a prior suit on the same patent versus the share of petitions on which at least one petitioner was a prior defendant, you get very different proportions. What does that difference in the proportions tell us? In the case of drugs versus medical, this is where it's sort of most clearly shown. Fewer than half of all the petitioners have previously been sued, but almost 3/4 of the petitions have at least one person who has previously been sued. This means that people who have been sued are joining up with people who haven't, and there's a sort of let's gang up on the patent owner. And I don't mean gang up in a sort of negative way, it's simply collective action. Let's get together, pool our resources, and go after our common enemy, this patent whose quality we question. And this strategic joinder is something that's not obvious from the sort of statutory design of the PTAB. So it's very interesting and important to recognize that this sort of thing takes place. What about the one-year bar? On the left side is a distribution of how long it takes from the first IPR petition that's filed and the first district court suit on the same patent. Okay, usually the district court case comes first, and then there's some lag of time in the first PTAB case filed. Yes, sir?
Is there a time span for these graphs? Is this since the beginning of IPRs?
So this study was published in 2016. So everything from the beginning of the PTAB, post-AIA, through June of 2016.
Do you know if, I can't remember, do you know if this is before or after General Plastics?
This is well before General Plastic.
Okay.
It is also before Wi-Fi versus Broadcom and before SAS Institute. Okay. It was right before Shaw Industries. And the way I know that is that Judge Reyna filed a concurrence in that opinion in which he cited this paper. I'm super excited about that. So if you look at the distribution of time between when the first district court case involving a patent is filed and the first PTAB petition on the same patent is filed, you see sort of a nice curve with a massive spike at the 1-year mark. Who knew? Patent litigators, like law students, work to deadlines. Right? They wait till the very last minute and then they file. And it's entirely sensible to give yourself as much time as you need. What about now this is first district court to first PTAB. What about last pre-PTAB district court? So the most recent before you go to the PTAB and first PTAB. You see the same basic effect, except the time is crunched quite a bit and the numbers are smaller because there's fewer intervals, but there's still that spike at 1 year. What this tells us is that adequate enforcement of the 1-year time bar is A, very important, and to the extent that the Supreme Court was confident that the PTAB would make more than they miss in terms of identifying real parties in interest, making sure that the 1-year time bar is properly enforced, this suggests that the PTAB A is doing a good job, and B recognizes that this is how litigants are going to respond. So the minute you stop enforcing this, they're going to take even more time. And the spike will sort of drop into the main distribution, which will spread out further. The fact that we don't see that pre and post SAS Institute is good evidence that the PTAB is doing a good job. Now that's the substitution side of things. That's how things were supposed to work and how things were actually working as a matter of substitution. Duplication, this is the work that I've sort of laid out in 2 recent law review articles. There is evidence that substitution isn't the only thing going on. Here's how to get there. First of all, when you reduce the challenge, right, the barrier to access for challenging patent, what do you expect will happen? Well, more people will challenge. That's great. That's what's supposed to happen. That's the feature of the AIA trial proceedings. Now, the targets of these are patents of questionable quality, but how do you know which those are? You can't conclusively know that beforehand. If you did, AIA review would be unnecessary, right? So what you have to do is make it easier to invalidate all patents in order that the patents of questionable quality will hopefully be disproportionately affected. And you won't end up having a bunch of collateral damage inflicted on patents that are of good quality, but are being targeted for other reasons, like they're super valuable. Or cover something that people really want unfettered access to. Okay. The place to begin, as with most good empirical work, I think, is start with the structure and then try to figure out what the data looks like. Because if you don't have a clear understanding of what the structure implies and what you expect, the data can sort of tell you anything, It's a little bit like, consulting a Ouija board. The first major structural feature that one should notice is that there are divergent legal standards. What do those standards look like? One is that in the PTAB, invalidating a patent requires a preponderance of the evidence. In courts, they require clear and convincing evidence. In the PTAB, until 2018, claims were construed according to their broadest reasonable interpretation, and in the courts, they were construed according to the Phillips standard. And broadest reasonable interpretation is more invalidation friendly, just as preponderance is more invalidation friendly. So there's a sort of thumb on the scale procedurally in the PTAB as compared to what's going on in the courts. Some of that's been changed. In 2018, the PTO did a rulemaking to align the claim construction standards. But there's not much the PTO can do about the burden of proof. That's written into the statute. So you have to, if this is a problem, blame Congress. I think that's a fair response. Now, what does this look like? The question about general plastic implicates this. The place to begin is internal duplication. We have serial challenges against the same patent in the PTAB. The share of IPR petitions that challenge an already challenged patent rose fairly quickly to about 40%. At one time, more than half the stuff coming before the agency was on something that had previously been challenged. And then you also get serial challenges across the court agency divide, which is what FinTIV is about. You've got a co-pending litigation in the district court. What should the PTAB do about that? And you could ask the same question framed the other way. There's something going on in the PTAB. What should the district court do about that? Which party blinks first? Is it the granting of a judicial stay, or is it the discretionary denial of a petition? If it ends up being a game of chicken, that's not a very efficient system if what you're trying to accomplish is substitution. The numbers more or less boil down to what's in the final two bullets here. Of all the patents that have reached an IPR final written decision, about a quarter of them have also previously received, at least one validity determination in the US District Court most of the time. So that means that these are final written decisions. The PTAB's gone all the way through, they didn't settle, they granted institution and were all the way through. A lot of these cases have already been looked at by the courts and decided by the courts, and a bunch of them were decided by the courts first. So it's not like they were proceeding in parallel and the PTAB finished first. The court finished first and the PTAB continued. Anyway, that is duplication. Maybe it's justified, maybe it's not, but we have to look very carefully at that question because duplication is the very thing we were trying to avoid. And here are those trends displayed graphically. Okay. Yes, sir.
How can you say it's duplication without positing that it's the same grounds of invalidity in both proceedings? Because there is no such thing as a determination of validity,
right,
as I think you described it there.
Yep.
There is only a determination on this set of grounds,
right,
that it either is invalid or is not invalid.
Right.
So these are orthogonal challenges in that sense, unless your statistics can align them to the same grounds of challenge.
Yeah,
correct?
Absolutely, that's right. And I'll do you one better. Unless we control for the same parties being involved, you might also raise due process grounds and say, just because that guy over there failed in court doesn't mean I, who am completely unrelated to him, should not be able to go to the PTAB. What this tells us is the outer bound of potential duplication. You can sort of whittle away pieces of it that don't involve the same product, don't involve the same parties, don't involve the same grounds, and so forth. So this is a first cut, and this doesn't get to the level of granularity that you're talking about. Yeah, absolutely right. Now, with this as our sort of empirical, first impression, let's consider what the causes might be. I've already noted that there's a weaker burden of proof, preponderance, in the PTAB as compared to clear and convincing evidence in courts. It's also the case that estoppel runs only one way. PTAB stops what goes on in the PTAB as well as the courts and the ITC. It's not clear that the PTAB should not be stopped by what goes on in other tribunals, but the way that PTAB has interpreted its own obligation to respect what goes on in those other tribunals has been quite narrow. And the Federal Circuit has more or less approved those interpretations, with good reason. Why would the PTAB say, we can't consider this because the court already said it was found not invalid. All they said was it wasn't shown to be invalid by clear and convincing evidence. The same evidence could theoretically, and in fact, quite often, as a practical matter, reach the lower bar of preponderance. The only way to know for sure is to not stop ourselves, not consider ourselves bound, and actually let the thing be litigated. That's an analytically consistent position. There's nothing wrong with that, okay? But the only reason it arises is that there are these divergent legal standards. So what happens when there are divergent legal standards of things like claim construction and varying rates of stays granted? The Eastern District of Texas grants stays pending IPR about 40% of the time. Northern District of California, that number is closer to 70 to 75%. I don't know what the right percentage is for stays, but the very fact that there's this massive variation tells us that litigants are in the driver's seat as far as where they choose to go forum shopping, and whatever the efficient answer is probably isn't being reached in a wide range of cases because we're so sort of scattered all over the place in that variation. Now, the question of USPTO power is a much bigger part of the paper. I'll leave it aside since it's not directly on the question of estoppel and duplication. But happy to talk about it in the Q&A if you're interested. I've written quite a bit more about this than just the empirical side of things. Let's consider responses. I addressed some of this in Patent Inconsistency, the most recent law review article, but also this is the subject of ongoing work on FinTech. So I'll share some sort of initial data with you on that and welcome your responses to that. How has the PTAB dealt with that internal duplication, serial petitions? Well, mainly it's through general plastic. They have the discretion to deny institution, and they exercise that discretion quite frequently. The point of a case like general plastic is not to establish that they have that discretion. That's pretty self-evident. With general plastic and other cases that I'll point to in a moment that are similar to it, what they do is explain to the public, explain to the parties, explain to attorneys, here's how we're going to exercise our discretion. Here's what's going to guide our discretion. We don't want it to be a black box. We're an agency, they say, and agencies are obliged to engage in reasoned, transparent decision-making. Here's us being transparent, right? So that's the system working the way it's supposed to. Now, internal duplication kind of shouldn't be something we have to worry about. Because for one thing, agency standards, it's all the same. And it runs bilaterally, the estoppel does, the claim construction standards are the same, the burdens of proof are the same. So we shouldn't worry about the kind of arbitrage between legal standards that we see between agencies and courts occur within an agency itself. Nevertheless, we do see a lot of serial challenging. So the PTAB developed a way to handle this. And that mechanism for handling internal duplication ended up being the basis for the court agency duplication control mechanism. Okay, so we started with this internal mechanism, then over time, when we reached the bigger real problem of court agency duplication, we already had a ready framework, we just extended a little bit. And here's how it works. There's direct control written into the statute. 35 U.S.C. 325D says, if there's another proceeding or matter involving the same patent, the director has all kinds of authority to do stuff like providing for stays, transfers, consolidations, terminations, and in particular, that duplication can be assessed by whether the same or substantially the same prior art is before the agency. So Congress clearly understood that this could happen even within the agency and gave the director a ready way to handle this. How do you evaluate that? Becton Dickinson tells us the factors to look for 325D discretion. That actually ends up not being used very frequently. What ends up happening instead is discretion under 314A. Section 314 is the statute that actually says that the director has a set of criteria, right, all through 312 and 313. You look at all those things, but at the end of the day, what you need is a sufficient likelihood of success. There needs to be a reasonable likelihood that the petitioner will prevail with respect to at least one claim challenged in the patent. challenged in the petition. Unless that is there, the director cannot institute, or the PTAB acting on behalf of the director. May not authorize unless. So it's a necessary condition. It's not clear whether it's a sufficient condition. What if such a criterion has been satisfied? At that point, does the director have to institute? No. We know that from the Supreme Court in Cuso versus Lee, 2016. They said there is discretion. And that discretion is not only substantial, but it's judicially unreviewable in all but the most extraordinary circumstances. Okay? So this is an indirect control mechanism. There's no indication that this statute was written with an eye toward giving the director all kinds of abilities to deal with serial petitions. It might have been simply, I want to exercise my policy discretion to focus on this category of patents or this industry or any number of other things that the director, being a political appointee, has the right to do. That is what this kind of discretion was probably aimed at, if it was aimed at anything in particular at all. But this is what the PTAB has really relied on for its discretionary denials. In the case that Roy mentioned, General Plastic interprets 314, not 325 discretion. Okay, so this is our starting point for managing internal duplication. What do we do about external interbranch duplication? Well, there are two cases. One is NHK Spring versus Intraplex, in which the PTAB extended General Plastic kind of a little bit. That's an understatement. The duplicative proceeding here was not PTAB petition and other PTAB petition. It was PTAB petition and a co-pending lawsuit in the Northern District of California. Okay? Should the PTAB care about what's going on in the Article 3 courts? People can disagree about that, but in NHK, the PTAB said the advanced state of a district court proceeding is an additional factor on top of the general plastic factors that we can consider. We finish within 1 year of institution. If they're going to finish first, they're going to finish sooner, they're going to finish much sooner than we are, then why wouldn't we take that into account, right? It's only sensible that judicial economy counsels us to conserve our resources and focus our attention elsewhere. And the advanced state of a co-pending district court proceeding is something it's not unreasonable for us to consider. Now, the fact that they're telling you they're going to consider it, they're putting it down in an opinion that you can look to is great. They don't even have to do that in order to exercise the discretion, but good administrative practice suggests that they should, and here they are. Okay? Now, how do you evaluate the advanced state of a co-pending district court case? PTAB gave us another case, Apple versus Finted, in which, lo and behold, a bunch of factors. We look at whether the parties are the same, look at the actual amount of time, look at whether a stay has been granted or is likely to be granted if institution is granted versus denied. There are all these factors in Finted. And so there's been effort to reduce both types of duplication. Now, in the paper, what I do is suggest some additional reforms, align the burdens of proof. Because the more that the burdens of proof are the same, the estoppel provisions are bilateral and the same, claim construction, PTAB still has the ability to go back and change it again. What rulemaking giveth, rulemaking taketh away, right? If you write it into the statute, you're codifying, again, this level playing field between the court and the agency. And I don't mean a level playing field substantively. I mean a level playing field procedurally. That's it. Bad patents should not survive because the patent office favors bad patents. Okay, and whether you think the patent office favors bad patents or not, that's a policy question that people, again, can disagree about. But as long as you're talking about this in terms of expertise and substitution, don't put your thumb on the scale of anything procedurally and let the facts work themselves out. You've got a bunch of experts evaluating your evidence. They will reach a better answer, a more reliable answer than the Article 3 courts, all else equal. This is my effort at making all else equal. Okay, so that's the sort of concluding point for the inconsistency argument as such. However, there's still stuff going on vis-a-vis duplication. NHK and Finted have sort of turned into a doctrine. And whenever something becomes a doctrine, it's useful to evaluate it, see how it's working and whether it's working well. From October 2018, when HK became precedential, through March of last year, this is what that data looks like. I've since updated the data from March of last year to March of this year, and I'll get to that in a moment as well. But literally just going through all the hundreds of opinions in the PTAB, one by one, and evaluating how they apply NHK or how they apply FinTIV to either exercise discretion and deny a petition or decline discretion and grant the petition. Here's what the numbers look like. They decline discretion pretty often, far more often, in fact, than they exercise it. And again, this only comes up if the case has merit. If there's a non-meritorious petition in front of you, it's not discretionary. PTAB has to kick it out, right? If it doesn't meet the requirements of the statute, PTAB's not going to say, we choose not to hear this. We have no choice except not to hear it. So when you take that into account, here's what the numbers look like. During that time, PTAB made 461 institution decisions. 72% of those cases, they didn't exercise the discretion available to them and granted. And the other 28% they did exercise. After NHK was decided, but before FinTIV came along and became precedential, it was used sort of unevenly. And the reason for that is that parties argued it somewhat unevenly. There has to be a co-pending district court case that you can point to. If you don't have that, this doesn't even matter. And when you do point to it, how you think the board should exercise its discretion is a little mushy until FinTIV comes along and says, here are your factors. Here are the subheadings for that portion of your brief. Just go through them one by one and explain to the board why they should decide this way. Now, Professor Narachani is looking at me because that's a very formalistic way to live your life, and as a former clerk to Justice Breyer, it's not a good way to live. But after FinTIV became the norm and these factors sort of showed up, right, the PTAB used its discretion in many more cases, in many more of the petitions than they had pre-FinTIV, where the issue was raised. It's important, I think, not to overstate the impact of NHK or FinTIV, because of all of these institution decisions, only a fifth were even decided under the NHK FinTIV framework. The others, it never came up. And if a petition, again, would have been denied anyway, there's nothing that changes. Of all the meritorious petitions, 93% of them are instituted, either because nobody raises NHK FinTIV or because they raise it and the board decides to institute anyway. Where there is a meritorious petition and the party, the patent owner raises FinTIV and the PTAB agrees and declines institution, all three of those things have to happen, and they only happen in about 7% of the cases that come before the agency. So this is a small, it's important, but small portion of what goes on in the world of PTAB practice. Okay, now, the fact that it doesn't happen very often isn't the end of the discussion, because maybe it happens in the most important of the cases. These are, of course, the ones that are being fought in 2 tribunals, or maybe more than 2 tribunals. So maybe they're unrepresentatively important. They're high stakes cases. They might involve much more money than the median PTAB petition. Those kinds of things are outside the scope of this study, although it'll be part of future work. But this is the work NHK FinTIV is doing. And here's the sort of real tricky part of the study. And it's what I'll conclude with. How are the FinTIV factors actually applying in practice? When you've got a 5 or 6 factor test anywhere in the law, common experience usually tells us that 1 or 2 of the factors is probably doing the heavy lifting, right? That's just how, look at fair use in copyright. Look at the factors for injunctive relief under eBay. It's usually one factor that's sort of doing that heavy lifting. Now, what's useful for me as an empiricist is that the PTAB is very structured about this. If you go read FinTIV opinions, there is literally a subheading for every single factor They say, here's the factor, here are the facts as we understand them, and this factor counsels in favor of exercising discretion, or counsels against exercising discretion, or is neutral. So when I'm training my student RAs to go through and code this, it's super easy. Just read it and put it into the Excel file, right? I love this. And the outcome in each analysis is binary. They either exercised discretion or they didn't. Each of these factors could go one of three ways: for, against, or neutral. And the final answer, after all the factors have been applied, is either discretion yes or discretion no. It's like, you know, the PTAB was begging me to run this regression, so I'm doing so. There's, this is a little mathy, but the basic idea is that there are probabilistic and logistic regression models that let you do this, where you have discrete variables. What I want to know from this is, are there variables that perfectly predict success or perfectly predict failure? If so, that would be very interesting, right? And if there are factors that correspond to each other very highly. Those factors that we looked at earlier here, if the court granting a stay counsels in favor every single time that the PTAB petitioner is the same as the district court defendant, then there's no reason for those two factors to be two separate factors, right? They're not doing independent work. The way we know that is they always rise and fall together. What I want to know is, do they in fact rise and fall together? And if they're redundant to each other, then maybe that suggests not that the framework is flawed, but that the factors themselves should be tweaked. That could be done judicially through precedential opinion decision-making, or it could be done by rulemaking, as any of this could be reworked through rulemaking. So what I want to know is not whether NHK and FinTiv are legitimate. That's actually a debate that's going on in the patent world right now. The answer to that is fairly straightforward. Discretion means discretion. If you liked the way the PTAB was exercising its discretion, 6 years ago and hate it now, get somebody else elected president who will appoint a director you like. I don't know what else to tell you. But discretion cuts both ways. And when you have a decision like Arthrex, and Professor Narachyan has written about this, and Professor Golden has written about this in some extent as well, as far as the political leadership, right, and what role that should play in the PTAB's decision-making, the PTO's decision-making, is that, yes, the PTAB is a group of experts, but they answer to a political agency head. And that's an important fact. We can't overlook that fact. We can't fixate on expertise to the exclusion of everything else, because you know what another word for political, which sounds kind of dirty when you're talking about expertise, you know what another word for political is? Politically accountable, democratically responsive. When you think of it in those terms, it's very important that we have some political check at the head of the agency. You have to know whom to blame. It can't just be a bunch of faceless experts whom you could never question and hold to account. So that balance is important. What I want to know from this work, this next set of work, is whether, after the data has been updated, the doctrine can be improved. Because administrative law is iterative. Agency practice, and I began my career at the USPTO, so I don't want to burn things down. What I want to do is make them better little by little. That's just a matter of temperament, I guess. One final thought that I'll leave you with. There were, like I said, about short of 500 decisions between September 2018 and March 2021. There were as many or more than that just in the last year alone. That means that the use of FinTiv as an argument that patent owners are raising is going up. It's becoming more and more a routinized part of PTAB practice to look at whether there's something else going on in the district court. And if it's used in a responsible way, the factors are doing meaningful work, we will probably end up with an equilibrium where the duplication is about as minimized as it can be. We'll never reach perfect substitution. But the closest we can get should be informed by the courts looking at what's going on in the agency and granting stays where appropriate, and the PTAB looking to the agency and granting institutions or denying institutions based on that as well. So far, it's been kind of lopsided, and most of the attention in patent law tends to go to the courts because the Federal Circuit has been at the front of that discussion for so long. But I think if we're going to take the Patent Office's ascendant role seriously, pointing out what they can do better is a good way to get us there. So with that, I welcome your questions and invite you to explore this and research, other research at NOMS. Let's have it. Yes, sir.
So, I guess one question I have is why, I'm not sure why you want to flatten the sort of burden of proof standard for showing invalidity between the district courts and the PTAB, because you're saying, well, the PTAB is expert, so why don't you want a lower burden to funnel more challenges there? You could also think if they're expert, then it makes sense that if we put some value on stability and patent rights, we, make it easier for the expert agency to overturn the patent rights than the less expert body that's in part reviewing, of course, a different basis, but in part sort of reviewing the initial decision of an agency to issue a patent for which the norm in administrative law is deference.
So I think I come at this from an error cost, decision cost sort of framework. I think the district court is less expert than the PTAB as to a particular patent, technology, case, et cetera, at the beginning of the case. But by the end of the case, the thing that makes district court litigation so time-consuming and so costly is that you have to teach the judge, the jury, et cetera, sometimes the law, but always the facts, the technological facts involved. At the end of the decision, the end of the case, by the time we've reached a decision, presumably the district judge has learned everything that needs to be learned in order to make a decision. Whether it's as good a decision as the PTO could have reached on a blank slate, setting that aside, if the district court has consumed enough resources, judicial resources and litigant resources, to learn, then at that point, they are not less expert in any meaningful way than the PTAB at the end of the case. The big disparity in expertise, I think, is at the beginning, which is why I'm so concerned with cases that have already been decided by the district court.
Yeah, I mean, I don't know. That doesn't sound extremely plausible to me, because partly there's, first of all, the expertise, developing expertise. When you're in a jury, you're listening to, it's adversarial litigation, as we were talking to before. Your experts, some might suspect, are mouthpieces for arguments that, are certainly serving the sides, generally, coincidentally, always serving the side that seems to be employing them. And then when you're dealing with something like non-obviousness, what does it mean to be non-obvious? And I would think, having experience looking at a number of different cases probably puts you, obviously there are problems even with the PTAB, but probably puts you in a better position to understand what that standard is intended to mean.
Okay, so if that's the case, if the expertise point seems implausible, here's a sort of alternative argument that will be less satisfying, but hopefully not totally unsatisfying. The difference in expertise is what leads to the high cost. Once you've expended those resources anyway, there's no relative cost saving to be had. At that point, you don't care about efficiency at all. All you care about is the marginal benefit of getting an accurate answer from the PTAB, right? That's going to come at the expense of the very stability that you alluded to. I think that's where the case for stability superseding the value of getting the right answer, costs be damned, becomes more important. It's not more important at the outset when we could choose which way to go, but we've already gone all the way down the district court pathway and all those costs are already sunk. The only thing left to be gained from going back to the PTAB anyway is a more accurate answer. And that's not nothing, but it has to be weighed against the stability and the sort of repose that's being denied to a patent owner that's just being inundated with repeat challenges. So that's where I think estoppel will do its work. It's where I think repose more generally will.
So I understand the premise that it may be more arduous and costly to get to the same quality of outcome. I'm not sure I buy it, but I understand.
Okay.
But if that was a stable premise, one would expect to be able to demonstrate statistically that against a base level, whatever you decide it to be, of invalid patents or unpatentable claims that have issued, that each of the tribunals would either efficiently, with starting with experts and getting done in a year, or with demonstrably non-experts but spending lots of time and finally getting to this same quality result, would determine the same percentage of patents to be unpatentable at the end of each of those days. And I haven't run those numbers recently, but my sense is that those are grossly different numbers. In the case of the district court, almost never is, I think, the number for invalidating in a district court, and pretty frequently, 50-50 is the number in the PTAB. So how can you reconcile those, leaving aside the a priori versus at the end of the day?
So I think there are two ways to get there. One, I'm not sure it's possible to demonstrate it empirically with great precision, only because there's a separate dynamic at work, which is, there's federal court, there's district court versus PTAB. There's also district court versus federal circuit. And you could have, and this came up in Teva, in the briefing in the Supreme Court, right? If claim construction is deemed to be a question of law, primarily a question of law, that's reviewed de novo, then the fact that this district court reached one conclusion on the claim of the patent, and this district court over here, construing the same claim, reached a different construction, that's uncertainty. There's discrepancy from one district court to another, and they're not binding on each other, so what are you going to do? Well, what you're going to do is, de novo on appeal, it will be reviewed by the federal circuit, and there will be conclusive answers. We don't have to worry about horizontal uncertainty, because the federal circuit will give us a conclusive answer. However, what that means necessarily is that the federal circuit is the only place you can get certainty. So vertically, the fact that the district court has said something is just the beginning of the conversation. You still have to go all the way to federal circuit conclusion before you get definitive answers. The benefit, conversely, of a clear error standard, which is what we ultimately wound up with, is that the federal circuit doesn't have to answer many of these questions. The rate at which constructions will be reversed is much lower, because it's a clear error standard, not a de novo standard. So there's more federal circuit deference to the district court's findings. But the cost of that, the thing you have to tolerate and be willing to live with, is that over here, this district court's not clearly erroneous finding and this inconsistent, not clearly erroneous finding of another district court are allowed to coexist. Okay? So until we can simultaneously figure out what the equilibrium between the district court and the federal circuit is, and the equilibrium between the district court and the PTAB is, I'm not sure it'll be possible to demonstrate that the baselines are in fact comparable. But the second way to get at this is you could say that your question ultimately boils down to, is the district court going to get this right more or less frequently than the PTAB would on a blank slate under the same conditions, right? If that's what you want, the fact that there are divergent standards only exacerbates the existing problem. So at very minimum, you want to be able to hold both of those constant, which is another reason to flatten the standards. But if you're concerned about the district court getting it wrong more often, lower the standards for both sides. Don't make it clear and convincing in the courts and clear and convincing in the PTAB. Make it preponderance in the PTAB and preponderance in the courts, and that will give the district courts more latitude to reach the right answer, just as the district courts would be getting more room to do in your hyper. So that's one way you could sort of get.
Well, I'm kind of persuaded by Professor Golden's point on the other thing, but we're sort of mixing and matching the evidentiary standard and the standard of review. And the standard of review as between the district court and the PTAB on the issue that I think is sort of most interesting here, it's sort of the scope and content, the motivation to find out, those sort of things. Those are, they're not identical words, but they're a lot closer. We aren't looking at a clear error versus a de novo review.
Yeah.
And both tribunals have the same standard, de novo review, on the claim construction issues. Those are aligned, and in fact, on the factual issues, they're close to aligned. So
That's right.
okay.
So yeah, 2 questions, so let me just.
I might suggest to further complicate things for you that
Please.
if you're trying to compare PTAB outcomes to district court outcomes, there could also be a survivorship bias, right? Because
Of course.
far and away the most common outcome, especially in district court, is settled payment.
Right.
And it seems like our cases, PTAB's cases, seem to settle less often. Who knows how that impacts things.
Absolutely right.
So 2 things. One, your second response, Professor Golden, just strikes me as an expression of the sunk cost fallacy. And I wonder why that isn't so.
I mean, there's no doubt that it's a
Right, so-
recognition of sunk cost. I'm not sure it's a fallacy in this case, because what you have is a trade-off between error and decision cost. Okay, so the fact that you haven't gotten the response you want is different from you haven't gotten a response you should be able to live with. That's a normative question. I think it's not a fallacy because the way in which the AIA was sold was as a more efficient way to get answers we should be able to live with, not perfect accuracy. It was not greater accuracy, it was just better decision-making through expertise. And you're getting more accuracy for the same amount of money. Now, if you take the efficiency piece out of it, then it's absolutely a sunk cost fallacy.
So we can talk more about this later, because that's actually not the question I wanted to ask. But
Okay.
I think we should just look at forward-looking costs
Okay.
from that point on, right? And the forward-looking costs include both the benefit of, we can forward-looking costs as weighted by the likelihood of an accurate outcome.
Yeah.
But as you know, I'm skeptical that there's an accurate outcome.
Right.
So I am also, I want to ask Professor Golden's question about flattening the standards, but through a different lens.
Yeah.
So, you might think that the reason we have divergent legal standards is not an accident, but rather because it embodies some policy choice about what ought to be patentable or not. That the standard we have for the PTAB is an expression of a particular policy choice that is different than the long-standing precedential policy choice. And so if we assume that precedent is sticky to change, in the courts, then we sort of have to ask ourselves how much duplication we're willing to tolerate in order to get a policy answer that we prefer from the PTAB. And I'm not sure how we do that analysis. How we sort of, how do we trade the costs of duplication against the costs of a judicial policy that we don't like, or the costs or the benefits of the expression of policy that is more democratically accountable? Is there a way to do that, or should we just do what's more democratically accountable?
I think
more
there's,
flexible?
I think there are 2 ways to do that. One is to start with the question of whether this is the sort of, and it's going to be a set of questions, it's not going to be a single question, right? But whether patentability, substantive patentability requirements are, and I don't want to sort of go all the way, turtles all the way down to whether patents are property or regulation, although at some point you may have to. One way to get there is to say, look, Congress historically has delegated interpretation of substantive patent requirements to the courts. Federal Circuit always did it. PTO never had substantive rulemaking authority. Now, the fact that they have adjudicatory authority that's formal enough to maybe ask for Chevron deference on what they think 103 means based on this PTAB final written decision is one way to get there. If the PTO is willing to expend political capital to ask the Federal Circuit for Chevron deference, in that case would almost certainly have to go to the Supreme Court. Right? If that's something the agency is willing to do, we could get at least half the answer to your question that way. And then the other half would be, is this a better judgment than what the Congress might have delegated to the Federal Circuit, consciously or unconsciously, or expressly or impliedly? The other way to get there might be to say, look, let's set aside formal adjudicatory authority. Let's just treat patents expressly like a form of public law, and just like telecommunications franchises and FCC licenses and so on, give the PTO substantive rulemaking authority. Now that's come up, as you know, many, many times, and it's always been shot down. I'm wary at your insistence of reading too much into legislative non-action, but I don't think there's a political consensus for that. And because there's not a political consensus for that, we have to sort of at least be skeptical of the idea that the agency is clearly the best expositor for the policy judgments embodied in making it easier to invalidate patents. I don't think it means we have to abandon that conclusion, but the road is a little bit steeper to get there, because history doesn't just matter in the courts. What the courts do historically is the backdrop against which any incremental changes at the margin have to be made to the agency, right? So the more you depart from that, the more you have to either consciously do it via legislation or consciously tell the agency through legislation, you can do whatever you want, and courts will at least have to defer to you under Chevron or something.
Yeah, so Chevron is one mechanism for this, but Arthrex, I think, complicates the story a little bit. Right? Because Arthrex is an expression of political accountability of the patent office. And so even without Chevron, right, Arthrex tells us the place for policy for these questions is the patent office. And that's important because of the political accountability.
Okay, but how is that policy going to be made? It's going to be made incrementally, case by case, in a backward-looking fashion.
It's not the best way to do it, but it's the tool that the agency has.
Right. So is it simply that the patent office is the best place, or it's not the best place, or is it sort of a middle ground? The patent office doing it this way is better than that, but it's not as good as the patent office doing it a different way. I think we could be a little more fine-grained about it.
Sure.
And that might be the second way to get at what you're talking about. If there's substantive rulemaking authority, that's a much clearer indication to me than the Supreme Court rewriting an unconstitutional statute, because what they would rather do is salvage it with a kludgy second best than to burn the whole thing down, right? I'm wary of reading that much into Arthrex, but not wary of, most of what you've said. I think we sort of disagree only at the margins. Okay, everybody's eyes have officially glazed over. My work here is done. Thank you all.